Some media law stroke criminal law developments. This is the tale of a woman called Miss Bakhtiari. I hope I'm pronouncing that correctly. Um, she was a student and she was in a very abusive relationship, and I think it is safe for me to say that, or at least she alleged that she was. But she did all the right things. She reported this to the police. She also warned some other people. This guy was involved in certain communities, like martial arts, so she just like alerted people there. So she did all the things that people get told to do, and she reported it immediately. However, her concerns were pretty much dismissed. Um, and the police questioned her mental health and her stability, despite there being no evidence whatsoever to support that. So, a little bit aggrieved about this, she went away. But then, after the Sarah Everard murder, she thought, well, hang on, perhaps somebody should be warned about this. So she just mentioned her experiences on social media, and she identified the guy. And the police arrested her for that. They arrested her for harassment. The guy also threatened civil proceedings, but he didn't go through with that. So she was arrested, and she was charged, and she was convicted at the magistrates' court, despite the fact she'd explained everything, and that the CPS hadn't challenged that anything she was saying was true. They just said that, well, just naming him because it, opens him up to abuse, although she hadn't in any way suggested anything should do anything. She just put it out there sort of as a warning to sort of perhaps avoid this guy or just keep an eye on him. She appealed. Now, you appeal a conviction in the magistrates' court generally by an appeal to the Crown Court. You actually have an appeal as of right. It's one of the few things you don't need leave to appeal for. And the case is heard by a judge and two magistrates. Unusually for appeals, this is actually what we call de novo appeal. In other words, it's a rehearing and it starts from scratch. Most appeals, the appeal court can only interfere with the lower court's decision if it was so unreasonable and so wrong that no reasonable court could have come to that decision. The mere fact they might have come to a different decision isn't a ground of appeal. But in this circumstance, where you go to the Crown Court, it is just a rehearing. However, before the rehearing, some very talented people at the solicitors and Doughty Street chambers, they put a skeleton argument, and they effectively raised three grounds. They said, well, hang on, this prosecution itself in the first place was flawed because it was in breach of the CPS's own guidance on how to deal with, DV. So they should have actually, they'd messed up in the first instance. So it wasn't right that they should prosecute somebody on the back of that. Also, it was a breach of Article 3 of the European Convention on Human Rights, which, among other things, puts a duty on the state to try to limit and try to prevent gender-based violence. And there's also a breach of her Article 10 rights. She was speaking out in the public interest on a matter of public importance, and she had a sort of valid ground to do so. Now, before the actual appeal took place, the CPS threw the towel in. They accepted that they had got it wrong. Yes, so she was rightfully, cleared her name. But there you go. I just thought you might find that, as always, vaguely interesting because it just shows there the tension between the criminal law and the civil law when it comes to sort of rights of privacy and harassment and confidentiality and defamation and all sorts of things. But there you go. If you found that vaguely useful, please consider liking, sharing, subscribing, and all that sort of thing.